Let's pick things up there with tonight's Technology Insider. Joining me, John Mahoney, national security lawyer with the Tully Rinke law firm. John, we've got a federal judge who says the secret collection of domestic phone calls is unconstitutional. He ruled that the bulk gathering of metadata violates privacy rights. Could his ruling open up the U.S. to lawsuits?
It really could. This is the most significant ruling under the FISA statute, holding that there's a potential likelihood that the collection of telephone records by the NSA and by the FBI is unconstitutional under the Fourth Amendment.
Now, the NSA has stood by its decision to collect metadata, claiming it's necessary for national security. Is that a claim that can be proven?
Well, it's very difficult, I think, for NSA to really be able to come forward in a public setting in a district court and explain how this program has been effective in thwarting terrorism. That's one of the points that the claimant plaintiffs make in this case, is that there is no proof that the bulk collection of domestic telephone records on all citizens, regardless of any allegation of wrongdoing, is really effective in the processing of national security issues.
Of course, we all know Edward Snowden brought the practice to light after leaking classified documents, and ever since he's been facing espionage charges. Now that the data collection is under fire, could Snowden be cleared?
Well, there is some push to give him some type of immunity in exchange for stopping the leaks. I mean, there are significant fears in the national security industry that there are more revelations that he may well be disclosing unless we can put a stop to that, either through imprisoning him or through some type of immunity deal.
Particularly if something happens to him, I've heard that if he's knocked off or something else worse than anything else happens, that then this secret file gets published that would even be more embarrassing. So yeah, let's make a deal, as Monty Hall would say. Snowden recently published an open letter to Brazil. He's offered to assist the government there with an investigation into U.S. spying. He's willing to do this in exchange for asylum. Is this a possible deal?
It is a possible deal. I know personally from my own experience that the country of Brazil is not happy with the revelation that the United States has been secretly hacking and recording telephone communications of government officials there. And I think, given the fact that the Obama administration has been attempting to build bridges and improve the relationship between the United States and Brazil, that this might come at a right moment for Snowden to actually get some immunity.
President Obama has been meeting with top tech executives at the White House. Healthcare.gov is one topic, but NSA snooping could be another. Last week, many of the companies represented in today's meeting sent a letter to the president asking for tougher restrictions on data collection. What responsibility do these companies have to their customers, John, when it comes to protecting privacy?
Well, certainly they do have a responsibility to protect their clients' privacy, but they have been ordered under the FISA and the FISC court to turn over metadata and other records related to telephone calls and also internet usage by American citizens. Now, according to the court decision, the internet usage data collection ended in 2011, but there is still a concern that the telephone records that are at issue in this case before the U.S. District Court in D.C. are ongoing. And for the past 7 years or so, the United States has ordered these internet companies and these telecommunications companies to provide on a daily basis, frankly, all telephone records of domestic and international phone calls. And this is the issue that Judge Leon in the District Court here in D.C. felt was something serious and could form the basis of a Fourth Amendment challenge.
Look how it's hurting companies like Cisco and others who are losing domestic business when companies say, hey, we think we don't want to do business with you because the NSA has the keys to the back door. Ironically, Huawei, the Chinese technology giant, is looking better now, because that's one reason why U.S. companies wouldn't do business with Huawei, because they feared Chinese hacking. Well, now we've got the same problem on other companies in this country, right?
Right. I mean, this is a very significant ruling. It's the first ruling where a district court has found that there are significant Fourth Amendment search and seizure problems with the way these telephone records and potentially the previous internet records collection have been undertaken. And if this case proceeds, it could go all the way up to the Supreme Court and ultimately sound the death knell to this NSA, data collection process.
It's always good to get your insight. John Mahoney, national security attorney with Tully Rinke. Thanks, John.
Thanks, Morris.